Hello, we will be doing our presentation on intellectual property. The company that we will be acting as is Viasat Incorporated. Viasat is a global satellite communications company that covers both commercial and military networks. We will be reviewing 4 documents. First, a non-disclosure agreement between Viasat and SpaceX. The second is a patent for a reconfigurable onboard processor. The third is a California trademark application for the logo of Viasat Inc. And last, a trademark licensing agreement between Viasat and SpaceX. Before we delve into the documents, let's preview what intellectual law is. Intellectual property law is a body of federal and state laws established to protect and enforce the rights of creative and inventive works, also known as intellectual property. These rights are secured through crucial aspects of intellectual property, including copyrights, trademarks, patents, and trade secrets. Copyrights are property rights granted by the U.S. Copyright Office to the author or creator of an original piece of work and last for the lifetime of the creator plus 70 years. This is assigned to the expression of an idea, but not the idea itself. Copyrights include the right to copy, distribute, adapt the original work. Examples include art, music, inventions, books, audio, and video. Trademarks are property rights given by the U.S. Patent and Trademark Office to protect words, phrases, symbols, or designs used by an entity to identify its product or services. Trademarks will last forever, or as long as it's continuously used in commerce. Examples include McDonald's golden arches, Nike swoosh design, or the red and blue chevron symbol for Chevron gasoline. Patents are property rights granted by the U.S. Patent and Trademark Office that grants protections for the new inventions, which can be products, processes, or designs. It prevents others from making, selling, or using or offering the invention for sale. It also promotes the sharing of new developments to foster innovation by protecting the design for a limited amount of time in exchange for publicly disclosing the patent's existence. For a patent to be accepted, it has to be a new, useful, and non-obvious idea. There are 3 types of patents. A utility patent, which is granted to anyone who invents or discovers any new, useful process, machine, article of manufacture, composition, or improvement of any of the others. A design patent, granted to anyone who invents new, original, or ornamental design for a manufacturer. Or 3, a plant patent, which is granted to anyone who invents or discovers a new, distinct variety of asexually reproducing plant. Trade secrets are business practices, formulas, designs, or processes used in a business designed specifically to provide a competitive edge to other similar businesses. Trade secrets are unregistered and would otherwise not be known to outsiders of the business as long as steps to maintain confidentiality are taken by the owner. Examples include the formula for Coca-Cola or KFC's 11 herbs and spices. First, we will look at a non-disclosure agreement, which is a legally enforceable contract to keep any trade secrets disclosed between 2 parties confidential. At Viasat, confidentiality is of the utmost importance. The company supplies satellite communications for some highly valuable customers and works with some of the biggest technology companies, including SpaceX, who will be launching their next satellite into orbit. This NDA outlines the key elements for confidentiality, including who are the parties, what is defined to be confidential information, how long the information is to be kept secret, and what are the consequences for breach of contract. In this case, Viasat is entering into a contract with SpaceX for a term of 5 years, and any breach would result in an injunction and monetary damages. One of the main reasons for an NDA is to protect an inventor's patent rights. Any person or entity can file for a patent. At Viasat, the patent rights belong to the inventor. However, under the employee contracts, Viasat has the right to purchase, use, or sell the product and collect a majority of the portion of the revenue from the product. The steps to file a patent application are to 1. List all the inventors and their residences. 2. Name the patent. 3. The address where the correspondence will be sent. For Viasat, all correspondence goes to their work address. 4. Include all drawings, specifications, CDs, etc. This is important because the filing fees are listed below and additional fees may be needed for more pages filed. 5. Decide how the patent application will be paid for, whether it's a check, money order, credit card, or bank account. 6. Mark whether or not the patent was created by or under contract for a government agency. 7. Lastly, sign and agree that the invention is your own. Next, a California trademark application. A federal trademark registration puts others on notice that your brand exists and is protected across the United States. Once your trademark is registered, it appears in the United States Patent and Trademark Office's online database. This database is available to the public and allows users to conduct a search to find potentially similar marks of their own. Additionally, once your mark is registered, you can begin to use the registered trademark symbol adjacent to your own mark. This way, anyone who views your mark, even in a simple search of Google, can identify that it is protected with a federal registration. Furthermore, no one can say they never heard of your brand before because U.S. trademark law assumes new companies are checking the USPTO trademark database and are doing their due diligence to avoid confusion. In this application, the applicant is prompted to provide basic information as well as specific description of the mark that is to be trademarked. Lastly, a trademark licensing agreement. In a trademark license agreement, the proprietor or licensor of a registered trademark gives authorization to another company, a licensee, to manufacture and distribute products under the trademark. The license is given for a specific range of products, typically consumer and fashion products, for which the licensee obtains exclusivity in a distinct territory, typically a country. In exchange for the rights granted, the licensee shall pay the licensor a certain amount of money and a percentage of royalties based on the sales value of the products sold under the license. In this case, Viasat is the licensor in giving authorization to SpaceX, the licensee, to use the Viasat trademark anywhere in the U.S. This is the end of our presentation.